Good morning, Your Honor. Richard Reinhardt on behalf of Appellant Gerald Leirer. I would like to reserve 5 minutes if I could.
Thank you, sir.
This case deals with solely the issue of the denial of the appellant's dispositive motion to suppress the search of his home back on October 23rd, 2015. The question for this court is, this court's going to review the application of the law to the facts de novo. As far as the facts are concerned, use a competent substantial evidence standard for the trial court's findings of historical facts. In this case, really, it's based on the affidavit. And there's not a whole lot of facts outside of that affidavit. Concerning whether the search warrant should have been granted, 2 prongs have to be satisfied, the commission element and the nexus element. In the commission element, it's clear that the affidavit doesn't establish that any crime that the affidavit alleged were violated, any statute, was actually violated.
The trial judge reasoning from cases in the arrest warrant context said that's not material as long as the facts alleged in the affidavit establish the commission of a crime. And then he cites federal cases that support the extension of that proposition to the search warrant context. I don't see that you take issue with that in your brief. Are you taking issue with it here?
I don't take issue with the idea that he found that there was probable cause established that several acts of lewd and lascivious essentially had occurred. I don't take exception to the trial court stating that it could make its own findings. But I do think it's important concerning the, what this affidavit is about in the long run, whether or not the search should have been upheld. In the affidavit concerning lewd and lascivious acts, there's no allegation of continuous abuse. There's no allegation that the abuse occurred routinely, daily, weekly, or even monthly. The allegation is that there's some, it looks like there's 3 possible incidents of L&L or possible abuse that occurred between September 2014 and March 2015. The affidavit does make it clear that that's the time period that we're working with. The affidavit was submitted on October 23rd, 2015, some 7 months after March of 2015. So 3 acts of L&L would possibly insertion of a vibrator, a fondling while the one girl that they're talking about in the affidavit was sitting on the computer, looking at the computer, and then oral sex with the other girl, the niece, potentially, of my client. The trial court clearly found there was no probable cause established for possession of child pornography, and apparently the appellee agrees with that. It doesn't, and its answer brief basically doesn't say that probable cause was established for possession of child pornography, and instead cites the trial court's findings that there was possibly PC for L&L.
Yes, you would agree, right, that the affidavit establishes probable cause, putting to the side the question of staleness.
Yes.
You would agree that the affidavit establishes probable cause that there was a nude photo of the niece on the computer, right?
Yes, sir. I don't take issue of that.
Okay. Now, the SB saw that photo
right.
while your client is alleged to have been fondling her while looking at the computer, correct?
It's alleged that she's looking at the computer, opens up a file, sees this, whatever this is, a photo of her girlfriend, the niece, and that my client has her sit on his lap and fondles her. That's
okay.
correct.
Why wouldn't it be, and I understand the argument in the brief to be, listen, we don't know if this was a pornographic video or a legit video or a legit picture.
Yes, sir.
Why couldn't a magistrate fairly infer from the context that it would have been pornographic? He was engaged in sexual conduct with SB at the time that it was seen on the computer. We know about past sexual acts with both the niece and SB. Why given these circumstances and the flexible standard we apply to probable cause questions, couldn't a magistrate simply say, listen, more likely than not that this was a pornographic image?
Because, and I believe that's part of the problem with the affidavit, that it is misleading in that respect. At the hearing, that officer admitted he did not know whether or not the photograph at question was pornographic. And this is after, his testimony is after the search warrant was executed and whatever evidence was found was secured. But the way the affidavit reads, it does not read that the photograph was used as an inducement to engage in a fondling of the child. It wasn't used as some kind of, hey, take a look at this, what do you think of this? It's ancillary. It's basically, she's looking at the file. He said that she could use the computer if she sat on his lap. So that's what she did. And then she was looking at the computer and opened up a file that showed a nude photograph of the other girl.
Yeah, I guess irrespective of whether or not the photo was an inducement to the lewd act in which the two were engaged at the time it was viewed, why wouldn't it be fair for a magistrate to find from the fact that, listen, they're engaged in a lewd act, there's a history of lewd acts with these two individuals, just given that overall context, it's more likely than not that this is a pornographic image rather than one produced for its artistic, scientific, or literary value?
Judge Leirer, that's a giant leap.
Especially because the affidavit also says, as well as other pornographic photos.
It does state that she saw other pornographic photos. That's correct in there. And again, I think that part of the affidavit and the way it reads is intentionally misleading by this detective. The detective admitted he did not know if that photograph was pornographic in nature, and yet he phrased it in there as if to say that it might have been. So I understand what you're saying, Judge Rothstein, and Judge Solario, with all due respect, this, in the affidavit, the girl describes the interior of the home where there's statues and sculptures of topless women and pictures on the walls of topless women. In other words, art that's in there, and they're making a point of this girl is making a point to point that out. So if you're asking, why couldn't a magistrate just assume this was pornographic in nature because he's engaged in some kind of sex act with the child, are we to assume that the sculptures and the statues of topless women are also pornographic in nature? Because it's pointed out in there also, the logic would be the same, would it not? He's engaged with the sex act.
I think the logic would be, listen, we have an affidavit that says that your client has watched these two girls engage in sex acts with one another, that he's bought them sex toys and inserted one of them into one of the girls, and has a history of sexual conduct with these two individuals. One of those two individuals is pictured in this photograph. Why isn't it a legitimate inference that photograph would be pornographic, given the history, rather than some other form of media?
I just think that bare statement itself, without any more information of how old the girl was in the photograph at the time the photo was taken, of whether, there's no allegation that the appellant is the one who took the photograph, that she was posed in any fashion whatsoever. There's no direct allegation that it was lascivious or lewd in any fashion or exhibited some type of sex act in the photograph. You're saying that a magistrate can just presume all of those things because a person's having, there's probable cause to believe that they had sexual contact with one of those two girls in the home. Let me ask you this. So a person who's charged with a sex crime, we're going to presume every single time that there's going to be, if there's photos of the child in their house, parents have nude photos of their nude children. It's not unusual, Judge Solario. Most parents, I would say, with small kids would have that.
This isn't a parent. This is a granduncle.
It's a relative. It's a niece. And what's not developed is how close they are as far as those two are concerned. You don't know that. You're presuming, this is my client's Fourth Amendment rights. You shouldn't presume and assume, concerning the Fourth Amendment, all kinds of things that are favorable to granting a search warrant once you hear that their probable cause was developed to believe sex occurred.
Fourth Amendment rights. What is the nature of the remedy that you seek? You seek a suppression, is that correct?
That's correct.
Is your client constitutionally entitled as a personal right to a suppression?
I'm sorry, say it again.
Is your client constitutionally entitled? Is there a constitutional right to suppression? I believe the case law says no.
Right.
Okay.
That's
so
correct.
At this point, the evolution of the exclusionary rule seems by the Supreme Court of the United States over the last 15 to 20 years to be narrowed. The presumption in the Fourth Amendment and others is that you go get a warrant, which they did here. So the Supreme Court seems to be arguing or telling us that the only time you should use the exclusionary rule is if you have wrongful police conduct, something that's willful and that type, arguably. So I guess in order to be entitled, and here's what I want you to help, to entitled to the remedy of suppression, would that rise and fall based on what you say are the intentional misstatements or omissions in the affidavit? Is that the level of wrongful police conduct that you're asking us to try to deter by using the exclusionary rule?
Well, the thing, there's two ways that you get around Leon. One is, I don't believe this affidavit establishes probable cause. Number one. Number two is, yes, I believe that the affidavit is misleading and intentionally misleading by the officer that put it there. I understand that the trial court said, well, I didn't take it as misleading when he's basically talking about the characters of digital evidence, which is not his expertise, and he admitted as much. But throughout that area of the affidavit, he states, based on my training and experience, based on my training and experience. It's not his training and experience, but that's based on.
It is, right? I mean, he testified to having training and experience. It seems to me that your argument is really not so much that the statement is affirmatively misleading, but rather that the officer was under an obligation to disclose that this information was really kind of based on or came from kind of the go-to guy in the local police office, right?
It's not his training and experience. It's his fellow officers' training and experience. He should have declared, if he's going to cite himself as essentially an expert in an affidavit to the magistrate, he should then say, where is this information coming from? Otherwise, the magistrate's looking at it saying, well, this guy knows what he's talking about.
Well, let me ask this question. We allow hearsay to be used to establish probable cause,
Yes,
right?
sir.
So if this affidavit had said, instead of what it said, listen, I went to the go-to guy in our office on child pornography and digital evidence issues, and he said all these things, would that have made a difference?
In the long run, no, it would have been honest to the court. And even the trial judge said, look, I'll exclude that. He still says he believes the nature of the digital evidence therein is common knowledge to courts. The problem with it is the way that the appellee has argued it below, and the way the trial judge ruled on it below, is that the photograph, you have to presume it's pornographic to believe it would have been a collectible item. And that all of that characteristic of digital evidence goes to files such as photographs. It does not go to internet purchases, which is the other problem. You're blurring the line between them wanting to look at the computer, they're not wanting to look at the computer to find the internet purchases of the vibrators. It's not alleged in the affidavit, yet the trial court talks about that, the appellee talked about that below, the appellee talks about that herein. That is not something that's common knowledge to courts, and quite frankly, I don't even know that you can recover internet purchases and records of that from one's personal computer. So maybe Amazon may hold it, Apple may hold it, Google may keep it for you, but I don't know that an officer can then go and examine, and a forensic expert can examine somebody's computer and determine all the purchases of consumer goods they've made over the internet over a 7 to 14 month period. So you're blurring those lines, and you're blurring the idea that a photograph described solely as a nude photograph is then pornographic and therefore collectible. Quite frankly, photographs are not collectible if they're not pornographic. The case law that the trial judge talks about, and the case law that the appellee cited, deals with pornographic photographs and files because of the very nature of them and being difficult to obtain, so that once you obtain them, the perpetrator, the possessor of that, wants to maintain possession of those items. Photographs are completely opposite of that, especially in the digital age. People snap photographs constantly. That's why we had cloud servers and stuff to try to store extra items away from your digital, from your computer.
Let me ask you this. Assume for the moment that we disagree with you on the question of whether or not this affidavit was sufficient to establish the pornographic quality of the photograph.
Yes, sir.
What would that do to your staleness argument?
If you're going to just assume that the photograph she's describing is some kind of pornographic photograph or file of the child, yes, the staleness argument is going to fall with the case law that's well established that you're going to be able to collect that and keep that for longer periods of time. But that's a huge presumption that I would ask the court not to take that massive assumption. Don't take the bait and just assume that. It's my position that when you're dealing with the Fourth Amendment and the affidavit is being presented to the court looks at the four corners of the affidavit. Yes, they use a common sense approach to it, but if there's not information that details that, and you're just going to assume that, you're going to open up Pandora's box. Essentially, for any time someone's accused of a sex act.
You are at that 15 mark.
Any time that someone's accused of a sex act with a child means that you're always going to be able to go in there and search every part of the house, including all their computers and stuff. The only part that wouldn't be stale in this case would be the computer files, if you believe that that photograph was pornographic. The bedding would be stale. The sex toys themselves, there's no, 7 to 14 months later. It's not an allegation of continuously doing it. There's no allegation in the affidavit, quite frankly, that the sex toys were stored at the house. You read the affidavit, it simply says that they were purchased online, and he told them, when you use them at my house, you're going to use them in these two rooms, and I'm allowed to be present. That's all it says. It doesn't state that it was required to be kept there by either of the girls, that neither girl had access to them or could take them with them. So again, you're presuming an awful lot that that's going to be found. So believe that. There's no question that the sex toys, staleness, they fall on staleness, which is part of the Nexus element, obviously. The bedding is 7 months to 14 months old, for God's sake. Even if you presume there was some physical evidence on there, 7 to 14 months later with washings and everything else is ridiculous. And there's no allegation in the affidavit that there would be DNA or any kind of bodily fluids contained on that bedding. So for that reason, Judge, I still believe that we're there. And that I don't believe that the appellee has established the factors in Leon to show that the good faith exception would apply to, they would be acting in good faith.
May it please the court, my name is Katie Ashby and I represent the state of Florida. To begin, it is the state's representation that this court lacks the jurisdiction to review the appellant's judgments and sentences in the lewd and lascivious case. As the defense counsel conceded at the sentencing hearing, the order that denied his motion to suppress was not dispositive on those charges.
Does that matter, though? I mean, we would still have jurisdiction to consider all of this in the child porn case, and then, whatever effect this has on his plea in the lewd and lascivious case, it has, and the trial court can sort that out. I mean, I assume we agreed with you. Does it? We're still deciding the merits issue, right? Right, deciding the merits issue as to the child pornography charges. If you were to reverse and this were to go back, I guess they had stipulated below that if he was successful in appeal, that he'd be able to withdraw his plea, and that would be up to the trial court, and that issue specifically would not be right for review at this time. As opposing counsel mentioned earlier, there are two elements to establish probable cause, the commission element and the nexus element. As he acknowledged that there was probable cause of the commission element, I would like to go on to the nexus element. In addressing staleness specifically, petitioner contends that appellant contends that because there was a several month span between the 7 months between the allegations and when the warrant was issued, that the information contained there is stale. However, staleness itself, there's not a bright line rule of time. There's not a specific lapse of time that's controlling as to that issue. But rather, in looking at that issue, it must be evaluated in the light of the particular facts of the given case, the nature of the criminal activity, and the evidence that's hoped to be found.
In this case, the ongoing nature of SB's allegations, various incidences that she talks about of lewd and lascivious behavior that range from September 2014 to March 2015, as well as the types of the evidence saw directly weigh against the evidence of staleness. Here, unlike drugs or currency, which would be considered consumable in the fact that it's kept for a limited time, all videos and photographs, not just those that are pornographic in nature, would be something that would be considered non-consumable and that they're likely to be kept for an extended period of time.
Well, there wasn't any evidence that he was taking videos when he was with them, was there? Or there was nothing in the affidavit that he was recording what was going on when they were in his house, was there?
No, Your Honor, but there was that allegation that he had...
One photo?
The photo, yes.
On the computer?
Yes, and even assuming, as opposing counsel has argued, that this photo wasn't an inducement of the lewd act, it still corroborated his lewd intentions towards AR. As seen in a case, Kane v. State out of the 4th, in that case, the court found that the admission of nude photos that the appellant had taken of his daughter were admissible as they, towards these allegations of abuse, as they depicted an unnatural and indecent disposition towards the victim. Moving on to the Franks issue that is raised. First, the issue was not preserved. At the hearing, opposing counsel had waived that argument that the officer had knowingly, intentionally, or recklessly, with direct disregard for the truth, had included those any false statements. Nevertheless, there's no...
He subsequently withdrew that waiver and the trial court accepted it, and there was no objection by the state, right? I mean, this... In other words, as I read the transcript of what happened at the suppression hearing, defense withdrew the Franks argument from the motion, then heard the officer's testimony with respect to his knowledge and experience with digital evidence, withdrew his withdrawal. Trial court said that's okay, and I didn't see any, the state jumping up and down and saying, Your Honor, you can't do that.
Yes, Your Honor. Even assuming that it was preserved, however, there's no evidence that there were any material representations. While there was while the applicant had inserted this boilerplate language, as he testified at the hearing, these facts are within his personal experience. He testified that he had been an officer for 13 years and a detective for 9 months, that he had taken, as a school resource officer, had taken annual training courses on child pornography. He had, although this was his first search warrant pertaining specifically to child pornography, he had been involved in several other search warrants that related to the seizure of computers and he had personal experience having just used computers in his daily life. He also had 10 years of military experience with naval intelligence and communications. He knew how to encrypt a file, and also he knew, and even assuming that this isn't, personal knowledge, this is common knowledge. So even assuming that for some reason that he did not have the common knowledge, the court could still go ahead and looking at taking out that evidence, the search warrant still had sufficient probable cause. Taking out the part pertaining to how this evidence is collected, there was still sufficient probable cause to show commission of the crime. To the extent that the To the extent that the appellant claims that the search warrant was overly broad and constituted nothing more than a fishing expedition, the state disagrees. As the trial court held in its order, given the ubiquitous nature of personal computers and digital storage media, an affiant is normally precluded from being able to describe the exact items that would be used.
Well, it doesn't really matter, does it? Because the pictures were found on the actual computer. They weren't found on any of the storage media or any of the external hardware, were they?
If my memory serves me correctly, there actually was significant evidence that they had been transferred. They found a SD card in a computer that I guess had that they had actually he tried to delete the photos off of, but that's where those originated, and then they had been transferred to multiple computers and some storage devices.
So it wasn't actually found on the computer that one of the victims, the victim was alleged to have seen it on?
The image was found on the computer as well as that SD card.
Okay.
Given the ease of transferring, the affidavit seeking this digital evidence will generally support an authorization, would likely authorize seizures of multiple devices. Here, as stated before, these images, this image was found, as well as many others, on multiple devices. And as stated earlier, the ability to transfer these are common knowledge. And on to the good faith exception, that basically even if this search warrant is fatally flawed, that the evidence would nevertheless have been admissible. In this case, as stated earlier, there's no evidence to suggest that Officer Wingate did present false information. As he testified at the hearing, this information was consistent with his personal knowledge. And on top of that, too, it is also consistent, as the court found, with common knowledge. So under that case, so under those facts, there's nothing to suggest that the officers acted anything but objectively reasonable in seeking to procure the search warrant. And as well as there's no evidence to show that there was any kind of misconduct to deter excluding this evidence. So if there are no further questions, the state will rely on its brief.
Again, Judge Solari and panel, I think assuming the photograph is pornographic is a huge leap in this case. And again, there's no allegation, as Judge Rothstein pointed out. There's no allegations that the appellant filmed these children, although there's allegations that he watched them. There's no allegation that he photographed them. There's no allegation that he had the girls pose in some fashion for taking a photograph. The idea that the photograph establishes probable cause or cooperates in L&L in any fashion is completely wrong unless one is to assume that the photograph is pornographic. And I will point out to you that the trial judge did not find in his findings of fact that the photograph was pornographic or that the magistrate could presume the photograph was pornographic.
Does the photograph have to be
I'm sorry, say that.
Does a photograph have to be pornographic if it serves to corroborate the witness's testimony that she observed the picture on there, and that would tend to be admitted into trial, would it not, as corroborative proof?
Corroborative of what? Of the fact that she observed the photograph? It certainly doesn't corroborate an L and L. It's
Something that a jury would arguably decide in credibility, would it not?
no more so than when she talks about the rest of the interior of the home. If we're just talking about the L and L charges, that, if we're just talking about those, then it doesn't really corroborate her testimony concerning the L and L above and beyond anything else that she's already talked about, having seen the general makeup of the home, proving that she's essentially been inside the home. But the photograph is tangential to the L and L the fondling that would have occurred on the computer. And again, I would just emphasize to you, the trial court did not find that the photograph was in fact pornographic. If it's not pornographic, it's not collectible, it doesn't, get past the stillness idea. And again, on this affidavit, we don't believe that the affidavit establishes probable cause or that any reasonable officer with decent training would be correct in relying on this affidavit, as well as the statements in the affidavit. Again, as far as whether or not they could reasonably rely on the affidavit, this officer apparently didn't seek any state attorney office input. He doesn't interview the niece before he goes and tries to get a search, the other child, to corroborate all this information. He doesn't include the appellant's denials of sexual activity with these kids in the affidavit to the magistrate when he's seeking the search warrant. So when he phrases the idea of a nude photograph with other pornographic materials, he's clearly trying to mislead the court. When he knows it's not, he doesn't have any information that it is in fact pornographic. So we believe that
This was not the Frank's argument you made to the trial judge, am I correct about that?
it's part and part, we talked about the affidavit doing that, but yes, I pointed out the fact that, you failed to include the interview of the appellant in the affidavit itself. I don't know that we sought testimony about whether or not he sought state attorney's office input. It's not in the record if he did or not. And we know, and I did point out that he's failing to interview the niece to corroborate and go further with his investigation. That's in the cross-examination at the motion to suppress.
I need to advise you their time has expired.
Yes, sir. Thank you, Judge.
Thank you, counsel. Thank you both.